Up next, I want to introduce Dana Syracuse from Perkins Coie. Perkins Coie has been another very strong legal partner of the Chamber of Digital Commerce. We invited Dax Hansen, who's a partner there, to serve as the chair of our state working group. And the team at Perkins has been incredibly helpful in terms of supporting this group and the work we're doing with the states. As you all may know, the states need a lot of help when it comes to blockchain technology. There's a lot of expertise, well, there's not a lot of expertise on the federal level, and to expect every single state to also have that expertise has been incredibly challenging. And we've had a lot of states that have reached out to us to be a resource, as you heard Jeremy Kaufman from Library give his testimony for New Hampshire, and Perkins has been with us every step of the way in that process. And Dana plays a key role in the state working group and the work that we're doing. And Dana has actually led some of the chamber's efforts, and I'll name out a couple of the stakeholders he's been involved with, including the state of Illinois, the Uniform Law Commission, and the Office of the Comptroller of the Currency, which is really stirring things up. So next, I want to welcome Dana Syracuse for a legal briefing. Thanks, Dana.
So, microphone's on. So my name is Dana Syracuse. I'm with Perkins Coie. My background is as a regulator. Prior to being with Perkins, I was Associate General Counsel at the New York State Department of Financial Services, where I was one of the drafters of the BIT license, helped oversee the chartering of ItBit and Gemini Trust companies, and helped oversee kind of the fintech process over at DFS. And indeed, my first exposure to the chamber was as a regulator when the chamber came in to advocate on behalf of the industry in that drafting process. Just turning to the first slide. So, I think that it's been a tremendously exciting and productive year on the state and federal level. I think that the states are finally seeing the need to be active, and as we'll go through in the presentation today, indeed the federal side has also been tremendously active with the SEC, the CFTC, the OCC, all attempting to stake a claim. But in terms of trends and use cases, digital assets, payments, remittances, smart contracts, those are areas where I think the regulatory framework is solid or solidifying. It's in the blockchain 2.0 and blockchain 3.0 applications where I think that there's still a tremendous amount of work that needs to be done in terms of educating regulators, both as to existing laws and regulations that could apply, and potentially ones that should be put into effect to help foster the technology. And these technologies, they cut across all industries, and because of the way the law is currently constructed, you could have industries putting together applications where you're tokenizing assets, but because of the way it's done, we'll talk about later, but because of the way it's done, you wind up getting absorbed into either securities issues or commodities issues or state regulatory issues. But this I think is a very important slide, and here you see starting in October 2008, that was when the Satoshi white paper was initially published, and then you had the first blockchain use case, which was Bitcoin. And really nothing happened on the regulatory front, or very little happened until March 2013, when FinCEN put out its initial guidance stating that exchangers, transmitters, and custodians needed to register as money service businesses. Then, about a year later, the IRS put out guidance stating that virtual currency should be treated as property for federal tax purposes. Well, that's interesting because you have the FinCEN looking at it as money, and you have the IRS looking at it as property. Then about a year later, you had the first piece of the first virtual currency regulation in the country, the BIT license. The Conference of State Banking Supervisors followed along soon after. And not a lot happened in that period. I think you had states and the federal government that were trying to get their arms around the issues. But then I think it was this past year where things started to get interesting with the OCC's initial white paper supporting responsible innovation. That was when we first got the sense that it was possible that the OCC was going to start regulating fintech companies. We didn't know what that meant. There was a hope that that would be a 50-state fix, meaning that certain types of companies that would be regulated on a 50-state level wouldn't have to go and do that. They could get one license nationwide. And the OCC has continued with that process, following through to even yesterday, where they put out a draft, a proposed draft stating kind of the criteria that they look for in licensing fintech companies. That's open for comment right now. The comment period on that closes 30 days from now. North Carolina amended its Money Transmitters Act to regulate consumer wallets. The SEC held a fintech forum where they stated that they felt they were best suited to regulate fintech companies. Illinois has clarified their money transmitter law to say that Bitcoin and just pure crypto activity is not covered. And it goes on. And you see, even just in the past couple of months, New Hampshire has a bill that may be signed by the governor exempting digital currency activity. North Dakota is looking into virtual currency activity. Washington State is likely to amend its Uniform Money Services Act to include virtual currency. Georgia's been active. And maybe perhaps sometime in July, the Uniform Law Commission will put out a piece of uniform legislation that could be enacted by all the states that would set forth a uniform criteria. Discussed that. But right now, these are the only 4 states that have taken concrete steps to deal specifically with digital currency. So what that means is if you're a digital currency company and you're trying to go nationwide, you need to go and then analyze each individual state statute or regulation. And they generally fall into 2 different categories. One category does the state money transmission law only cover money? Another category would be, does it cover monetary value? Well, for the ones that cover monetary value, you have a possibility that it's going to govern pure crypto activity. Rather not cover pure crypto activity. So if you look at the states, on balance, about half the states would cover crypto to crypto activity and crypto walleting services, and about half the states would not. But if you don't do that analysis, you run the risk of engaging in unlicensed money transmission. International activity, it's definitely been quite active. People's Bank of China is conducting inspections of exchanges there. I'll just let everyone read this, don't have to go through it in detail. But the point is, on the international front, we're also seeing increased activity. And I think a lot of that is a result of the excitement over blockchain, the potential for nations such as India to move to a completely cashless system, and an overall embracement of it. So, as I mentioned earlier, the SEC had a fintech forum in October where they said that they could be the premier regulator for fintech companies. But what have they actually done in the past year? Well, one place where crypto companies wind up interacting with the OCC is when they're doing things like ICOs, which would require an analysis of, are you acting as a security? And that winds up being a 3-part test under Howey. Is there a reasonable expectation of profits? Are you engaging in a common enterprise? And is the activity derived mainly from the efforts of others? Which winds up being a quite complex analysis. The other place where they've been very active over the course of the past year is in ETFs. Right now, there are there were three applications. One has been denied. It was an application by the Winklevoss Bitcoin Trust to get listed on the BATS exchange. Now, the denial didn't go to the substance of the application, but rather an overall concern that many exchanges, the wider spot exchange market, remains unregulated. And for that reason, the BATS exchange wouldn't be able to enter into the necessary surveillance sharing agreements that would allow them allow proper supervision. And really what this harkens back is to the notion of like, where are we in the progress of the ecosystem? Where does more regulation need to be where's more regulation needed? And where is advocacy needed? And that's where, that's where the chamber comes in. That's where industry that wants to actively interact with regulators, that's where it becomes very important, because I think a lot of regulators, there is a political fear where they don't want to stick their neck out. They don't want to be they don't want to be the one on the chopping block. I think that people saw criticism against New York with the bit license, and they don't want to engage in that political risk. But the more you have a dialogue between the community and regulators, I think it creates for a far healthier ecosystem. And that's kind of what the OCC is trying to do. The OCC has started their fintech innovation process, and one key step that they've taken is opening up the Office of Innovation. That opened in October, and it's going to have 3 offices: New York, DC, and San Francisco. And what they are encouraging is for industry, to the extent you're not going to apply for a fintech charter, but to come in and interact. I think a lot of those companies coming in and interacting could potentially be deemed third-party vendors and captured under the OCC third-party vendor regs. So it's a communication that could happen. It's a communication that is useful, but it's one that I think industry needs to be careful about. So the process with the OCC is not yet complete. As I said, the OCC is still accepting comments on the current white paper. But one thing that they did do is they digested the comments that were received in response to the December white paper. And there were a couple, the community got some important feedback there. One is the notion that the OCC is not going to take the step of going for light touch regulation. So one of the points that was requested was, well, fintech companies, they're new, they're young, they should be subject to some sort of lighter supervision, lighter capitalization, et cetera. The OCC said that that won't be the case because you will be receiving a bank charter. That's essentially what they said. I think it's still an important point for the community to push back on a little bit, because the notion that they want to regulate fintech companies, that's great. Fintech companies, by the way, they're engaged in one of the 3 core banking functions. But I think that the applicant pool may be less if they're going in and going to be subject to high capitalization and high supervision. The CFTC, I've only got a couple minutes left, but they have also been quite active. There was an enforcement action against Bitfinex earlier this year, where the criticism was if you have a exchange that's engaged in leverage or margin or finance trading, that can fall under the CEA. They had previously said that they viewed Bitcoin as a commodity. So it's very clear that if you're engaged in this type of activity, you must register with the CFTC. But the question is, can you actually show actual delivery with Bitcoin? And the CFTC hasn't really come out with a clear statement on how that can occur. I think that over the course of the next year, as leadership solidifies at the CFTC, as it solidifies at the SEC, and we'll see what happens when a new comptroller comes in over the OCC, what their policies are going to be. But clearly the trend is forward. Clearly the trend is seeing the importance of fintech, seeing the importance of blockchain, seeing the importance of digital assets on our capital markets, and an overall desire to play a role. And I think that as the federal government acts more, you're going to see more activity out of the states. You're going to see the states realize that if they don't up their game, they will lose their role as, as a prudential regulator. So I think the overall story is one of forward momentum. The overall story is one that I think is positive for everyone in this room. Thank you.